If we could just have you take your seats, please.
Yes, sir.
The light there on your mic.
I heard.
Got that. Okay.
I heard.
Awesome. Good to see you again, sir.
My pleasure. You flying okay?
Yeah, our flight taking off for
It is? We can help them? Okay, I'm Jenny. It's only your baby. Yeah. I have your email, but I don't make sense to ask.
No, I've got
Thanks, Sean.
afternoon. Thank you all so very much for being here. I see we have been joined by the mayor of this great city. Mayor Woodfin, please join us for a moment and give us a few words of greeting. Just come on up.
Good afternoon, everybody. Maybe it works, maybe it doesn't. I'll be brief because this room is packed and we are here for a very important topic. Let me first start by thanking these strong leaders you see seated before you.
Use one of these mics right here, please.
Ma'am, I'm going to use the mic. What about this, everybody?
You got it.
What about this, everybody?
All right.
Let's try this again. Good afternoon.
Good afternoon.
My name is Randall Woodfin. I serve as the mayor of the city of Birmingham, and we are happy that you all have chosen the city of Birmingham to have this very important discussion and hearing. On behalf of the citizens of Birmingham, this is what I'll say. For all the issues facing our country, for all the ways people are fighting, it's good to see some good folk fighting on our behalf.
Thank you. Thank you.
And I'm speaking to pretty much all Americans in this country about a very important topic that I feel is under assault, personally. And to my congresswoman, I know the fight you've personally taken on this, and I want to say thank you. To Representative Fudge and to Representative Butterfield, thank you all for being in our city. And let me get out of the way. Thank you.
Thank you, Mayor. Thank you. Thank you for allowing us to be here in this chamber. We appreciate it. Let me just give you all a couple of housekeeping things before I actually open the hearing. One is we are live streaming this, so you may be on at any time. So just understand that it is possible you will be on the live stream. So nobody will be doing something silly and not realize you're being on television. So. I do have some family here that, since I'm the chair, I can just do this. I have some family here. Could they just stand up? My family is from Birmingham, so I just want my family to stand up. And of course, there are a lot of women out here in red, my sorority sisters, if they would stand up. Members of Delta Sigma Theta sorority. No, I'm here. You introduce your people. Listen, Terry thinks I'm gonna introduce her mother just because she didn't want to forget. Miss Sewell, please stand up. This is Terry's mom. And I have a former colleague here, but Terry's going to introduce the elected officials so that I won't make a mistake. The Subcommittee on Elections of the Committee on House Administration will come to order. Let me thank the members of the subcommittee and my colleagues from the House who are with us today, as well as our witnesses and those in the audience for being here today. I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks, and that any written statements be made part of the record. Hearing no objection, so ordered. I ask unanimous consent that Ms. Sewell be invited to sit on the dais for the subcommittee hearing today. Hearing no objection, so ordered. Good afternoon. Good afternoon. I want to give a special word of thanks to my distinguished colleague, Ms. Sewell, for her warm welcome to this district. As we continue this important work, I want you to know that you have an outstanding representative of Congress. And today we are here to examine the state of voting rights and election administration in Alabama. As this subcommittee travels the country, it became clear we needed to come to Alabama, the home of Selma, Montgomery, and Shelby County, the place that started it all. The right to vote is fundamental to a strong, thriving democracy. And yet, in our travels around the country and here in Alabama, we have seen repeated attempts to suppress the vote through overt tactics such as those seen in North Dakota and North Carolina, to sometimes more covert tactics such as constant election administration changing in places like my home state of Ohio. The people of Alabama have marched and bled, gone to jail, and some even died for the fundamental right to vote, the right to participate in the democracy that governs their very lives. Nearly 6 years after the Supreme Court decided Shelby County v. Holder, we know that voter suppression and discrimination still exist today. Administrative barriers that may have previously been denied by the DOJ disenfranchise voters through changes to polling places or voter ID laws that create new forms of poll taxes and other changes. Alabama has closed polling places, enacted a strict voter ID law, been slow to restore the rights of previously incarcerated citizens, attempted to close DMV offices that issue the valid IDs in predominantly minority areas, and more. The greatest democracy in the world must not regress. We must recognize our faults and continue to move forward. We must progress. Chief Justice Roberts said himself, discrimination still exists. We must acknowledge this fact and do all we can to ensure that every American can exercise his or her right to vote. Overcoming barriers to increase voter turnout does not make those barriers right. Today, we will hear from experts, activists, plaintiffs, and litigators who have worked for years to ensure that every Alabamian can exercise his or her right to vote. Their testimony will help as Congress seeks to understand what needs to be done to safeguard every American's right to freely access the ballot. I would now ask for opening statements from my colleague, Mr. Butterfield of North Carolina.
Let me begin by thanking you, Chairwoman Fudge, for your leadership on this issue. At the beginning of this Congress, Speaker Nancy Pelosi looked among our Democratic caucus and looked for one to lead this committee. And it was no question that the one who was ready, willing, and able to serve in this important position was Congresswoman Marcia Fudge. Marcia is the chair of the Election Subcommittee. There are, I guess, 4 Democrats and 2 Republicans, I believe. 6 Democrats and 3 Republicans on the subcommittee. We have been holding field hearings all across the country. We started in Brownsville, Texas several weeks ago and have just meandered our way all across the country. And for some reason, every city that we go into, there's always a sea of red in the audience. Except for North Dakota. I don't know what happened in North Dakota. But we started off in Brownsville, Texas, and went over to Atlanta, and then down to North Carolina, and over to Cleveland, and last week we were in Broward County, Florida, and today we are here in Birmingham, and it's our joy to be here. I always make these comments at the beginning of each hearing, and that is to remind, of course my colleagues certainly know it, but to remind those who are listening that this is not a political rally. This is not a political convening. This is an official congressional hearing of the United States House of Representatives. We are engaged in a very serious process of collecting evidence that will either support or refute claims of voter suppression that are taking place all across the country. We all know about the 1965 Voting Rights Act. The Voting Rights Act was enacted several days after I finished high school in 1965. It was a very powerful piece of legislation, very powerful. I practiced as a voting rights attorney for some years, and even I did not realize the power of the Voting Rights Act until I got deep into the weeds in litigating these cases. The first thing the act did was to eliminate the literacy test, and you certainly know all about the literacy test in Alabama. The second thing it did was to give minority communities, regardless of where you're situated, the right to bring an action in federal court if you feel that your vote is being diluted or that your community's vote is being diluted because of race. We call that Section 2. It is nationwide. It is not limited to any particular jurisdiction. However, Section 5 is different. Section 5 was limited to several southern states in their entirety, Alabama being one of those, my home of North Carolina. It was only limited to 40 states, and Congress enacted a formula that determined which jurisdictions were in and which ones were not in coverage under Section 5. Southerners have been, many Southern elected officials and those in office have resisted Section 5 for generations, but we have always come out on top every time there was a challenge to Section 5. But unfortunately, in 2013, in the Shelby County case that you know so well, we were dealt a severe blow by the U.S. Supreme Court. The court told us that Section 5 is a constitutional provision of the Act, but that the formula that was used to determine which jurisdictions are covered was an outdated formula and needed to be updated. And so therefore, the court has called on the Congress to update Section 4. We cannot just flip a coin and decide which states, which counties are included under Section 4 and 5. We've got to collect evidence to support that. And that's why we're here today, to collect evidence, to build a congressional record so that we can reauthorize Section 4. Congresswoman Terry Sewell has a very profound bill that's pending in the House, and hopefully it's going to be marked up and heard later in the year. But we're going to decide how to enforce Section 5, and we need your help in building this record. So thank you to the panelists for your testimony. I see them nodding their heads. They know exactly what I'm talking about. This is just not a feel-good exercise today. This is building a congressional record so that we can protect the right to vote in the United States of America. Thank you very much.
Now, I'm going to ask you, if you would, please silence your phones. And as we know that, if you look at television at all, if you read anything, you understand that we are under siege in this country, especially the people of color, poor people, and immigrants. And I want you to know that your congressperson fights every day to represent not only you, but people like you all across this country. I would now recognize my colleague from Alabama, Ms. Sewell.
Thank you so much, Chairwoman Marcia Fudge of Ohio. I want to thank Chairwoman Fudge of Ohio and Congressman G.K. Butterfield of North Carolina and the Committee on House Administration Subcommittee on Elections for holding this field hearing right here in Birmingham, Alabama. I want to thank Mayor Randall Woodfin and the Birmingham City Council for allowing us to host this field hearing right here in City Hall, in the council chamber. Likewise, I'd also like to thank all of the witnesses. You have a very important role to play, as Congressman Butterfield has said. I'd also like to take a point of personal privilege to acknowledge in the room today is former Congressman Earl Hilliard Sr. Will you please stand, sir? He was the first African American since Reconstruction to represent the 7th Congressional District. We also have in the audience my mentor. I clerked with him. He was the first federal judge in the state, black federal judge in the state of Alabama, Judge U.W. Clemens, who served on the federal bench for over 30 years and to whom all of us owe a debt of gratitude for your service, sir, in the judiciary. I'd also like to acknowledge all of the elected officials who have blessed us by being in this room. Will you please stand? We have elected officials on the state level, state representative, and we also have local representatives who are here. If any of our city council members are here, I would like to recognize them as well. I also would like to take a personal privilege and acknowledge my mother, who's already been welcomed warmly, but also the ladies of AKA, as well as the ladies of Delta Sigma Theta from Birmingham, Alabama, and Tuscaloosa, Alabama, who have made their way here today. I want to thank all of you for being here, because we know how important voting rights is in the state of Alabama. I think it is very befitting, Madam Chair Lady, that we are here in Alabama, befitting that this committee would come here to Alabama to hold one of its 7 field hearings. After all, it was the citizens of Alabama, many the citizens of my congressional district, that had the audacity to march, pray, and die for the sacred right to vote, which led to the voting rights passage of the Voting Rights Act of 1965. And it was also in the state of Alabama, in Shelby County, that brought us the landmark decision of Shelby County versus Holder in 2013 that nullified Section 4 and gutted Section 5 pre-clearance provisions of the Voting Rights Act of 1965. And we're honored to have on our first panel Councilman Ernest Montgomery, who was one of the official plaintiffs in the Shelby County versus Holder decision, and who has now taken his rightful place as a councilman for Calera Calera, Alabama, after making sure that he and all of his constituents had the right to vote. I just want to say in the closing of my opening statement how important it is that we create this record. Old battles have become new again. Many of us thought we had already fought the battle and won the battle for the right, equal right of all Americans who reach the age of 18 to vote in this nation. And what we have seen with the Shelby decision is a rolling back of protections that had been there. And it's incumbent upon Congress to come up with a modern day formula. And I am proud to have as H.R. 4, the Voting Rights Advancement Act, as my seminal piece of legislation that will actually put a modern day formula. This hearing, as well as all of our field hearings, are critically important, and you witnesses are critically important in providing that record. People need to know what is happening in states all across this nation since Shelby County. I think that the 2018 election is proof positive of the need for a stronger Voting Rights of 1965 Act. And that's because we saw in Alabama and 20 other states invoked more restrictive voting laws since the Shelby County decision. It may sound innocuous that you have to just present a photo ID, but it used to be that those who were disabled could present a validly issued federal ID called a Social Security card and vote in Alabama. That is no longer the case. And it is unfortunate that we are making it harder for people to vote and not easier for people to vote. So I want to thank this committee for coming here. I want to thank all of our witnesses, and I want to thank you, the audience, for your interest. But it's incumbent upon all of us to make sure that our voices are amplified at the injustices that we see in voting all across America, and especially in Alabama. Thank you, Madam Chair.
I'll now introduce our first panel. Just a reminder, each of you will be recognized for 5 minutes. Your written statements, of course, will become a part of the record. You'll have 5 days to add additional material if you so wish. James Blacksher, Esquire. Mr. Blacksher has been a civil rights lawyer in Alabama since 1971 and has been the counsel on record in numerous landmark voting rights cases. Mr. Blacksher is currently co-counsel with the Legal Defense Fund on a Section 2 case, NAACP versus Pleasant Grove, challenging the city's at-large method of election for city council. Mr. Ernest Montgomery, council member Calera, Alabama City Council. Mr. Montgomery has lived nearly his entire life in Calera, Alabama. Mr. Montgomery was the only African-American member of the 5-member city council when the city withdrew its district lines, diluting the African-American vote. The ensuing battle over the election became the basis for the eventual Shelby County v. Holder case. Ms. Jenny Carroll, professor of law at the University of Alabama and chair Alabama State Advisory Committee to the U.S. Commission on Civil Rights. Ms. Carroll is the Wiggins, Childs, Quinn, and Pentassis professor of law at the University of Alabama, where she joined the faculty in 2014. In addition to serving on the law school faculty, in 2016, Ms. Carroll was appointed chair of the Alabama State Advisory Committee to the U.S. Commission on Civil Rights. Mr. Montgomery, you are recognized. You'll see a light system in front of you. When the light turns green, you may begin. When it turns yellow, you have 1 minute left in your time. When it turns red, we would hope that you would start to wrap up. You are recognized, sir.
Perfect. Yeah. Now it's on.
Thank you. Again, thank you, Madam Chairperson, and to the other congressmen who are here. A little nervous about this here, but we are happy and thankful for the invitation you have given to us to come speak in this field hearing. Again, my name is Ernest Montgomery. I'm a city council member from the city of Calera, located in the southern part of Shelby County. Ben, I was a resident in Shelby County in 2010. I became one of the interveners in the Shelby County Shelby versus Holder case. Like many of my friends and associates, I knew very little about the Voting Rights Act prior to 2010 and had no knowledge much of the pre-clearance section of the Voting Rights Act. But it was, I'm sure that it was not taught during any of my civic or democracy classes. But anyway, I was privileged to witness every step of the oral arguments. I learned about the states and the jurisdiction that was under the covered provisions, and I learned why. After sitting in and hearing the arguments in the district court and in the appeals court, and finally in the Supreme Court, keeping an open mind, I could clearly understand how after Reconstruction, say in the mid-1800s or the latter part of the 1800s, how it had disenfranchised such a large portion of our American population prior to the 1900s. I do understand now how important the power of the vote is. I believe the greatest survivor to our democracy is the power of the vote. Our government must commit to assuring that every legal citizen be included, every barrier that prohibits be destroyed, every election from our local schools all the way to our federal elections be fair. I hope our elected leaders in Washington, D.C. can soon come up with some solution to protect every person's right to vote by some formula or preclearance. For we all know, as has been said, that 1 ounce of prevention is more valuable than a pound of cure. Thank you.
Good afternoon, Chairwoman Fudge, Representative Sewell, Representative Butterfield. Thank you for inviting us. Thank you for coming. I'm James Blacksher. Yeah, I've been litigating voting rights cases for a lot of years. Today, African Americans are the largest minority group in the state of Alabama. According to the most recent U.S. Census Bureau estimates, blacks constitute approximately 26.5% of the Alabama population and 26.2% of the voting age population in Alabama. Latinos are about 4% now of the population and 1.7% of the voting age population. Alabama's motto is, "We dare defend our rights," and throughout its history to the present, Alabama has invoked states' rights to preserve white supremacy and to subordinate its black citizens in the political, social, and economic role of a cheap labor force. The most crucial component of this white supremacist policy has always been either denying or suppressing the right to vote of African Americans. Oh, I need to bring it closer?
Thank you, sir.
Okay. When the Supreme Court in Shelby County versus Holder 2013 held that things had improved in Alabama and in other previously covered states with respect to the suppression of black vote, they pointed to data that were the product of the enforcement efforts of the federal courts and the Department of Justice. The state of Alabama has never voluntarily taken any action to provide equal opportunity for its black citizens to vote or to have access to equal opportunity in the political process. What the Supreme Court in Shelby County refused to acknowledge was that even though these numbers are up, what still remains is what I call the architecture of white supremacy. And that's embedded in Alabama's 1901 Constitution. In 1985, in the case of Hunter versus Underwood, the Supreme Court of the United States, in a unanimous decision written by Justice Rehnquist, said that the states acknowledged that in adopting the 1901 Constitution, the purpose of the convention was to establish white supremacy in this state. Today, in federal court actions that I'm involved in, the state of Alabama is taking as much advantage of Shelby County as it can to reclaim the benefits of this architecture of white supremacy. In doing so, it is arguing that the equal sovereignty principle cited by Justice Roberts in Shelby County is a call for the reassertion of states' rights and demanding that federal courts presume that today's Alabama legislature is acting free of any racially discriminatory motives. That's why I have devoted most of my written statement to demonstrating how that architecture is still there. And given the opportunity, I would like to emphasize 3 recommendations that I hope this committee will take into serious consideration as it drafts remedial legislation for the future. And I see my time is nearly up. Say again? You know how lawyers are. Yeah, okay. Well, the first recommendation, of course, is to restore Alabama and other states who practice Jim Crow and suppress the voting rights of its black citizens for years and years, to restore it to coverage under Section 4. Section 4B of the Voting Rights Act. It's ironic that the Supreme Court in Shelby County did not cite any provision of the United States Constitution that the 2006 Voting Rights Amendments violated. Instead, Justice Roberts based his decision entirely on an extra constitutional principle of equal sovereignty of the states. And that equal sovereignty principle can be traced back to its origins in an 1857 case called Dred Scott v. Sanford.
You know, we're going to put a pin in that, and we're going to come back when we get into the questions to go more into detail with that. Right. So.
But my first, I started to preach then, is to restore Alabama and other southern states to coverage under Section 4. My second...
Okay, now you have to give them to us quick. Just tell us what they are, and we'll come back and get into
the second is to amend the language of both Section 2 and Section 5 to make it clear that state actions that discriminatorily deny or abridge the electoral power of protected minorities and their elected representatives after the election are also matters involving their voting rights and deserve protection. And finally, my third recommendation, and I make this on behalf of my co-author, Lonnie Guinier, who urged on us when we were writing an article for the Harvard Law and Policy Review to press Congress to use its power under Section 5 of the 14th Amendment to restore the right to vote in Section 1 of the 14th Amendment. The Privileges or Immunities Clause was originally intended by the drafters of Section 1 to include a right to vote. What is the most important privilege or immunity of citizenship in the United States?
Thank you, Mr. Blackshear. Thank you so much. Ms. Carroll.
Thank you.
Since the Shelby County decision, Alabama has passed and implemented a variety of regulations on voting. While these regulations are facially neutral, they raise real concerns about the opportunity
Just pull it down some, you should be fine.
of enfranchisement among the very population that the Voting Rights Act was designed to protect. The days of a sheriff standing in the doorway of the polling place may be a thing of the past, but current voting regulations may produce the same effect on minority and poor populations in our state. The method may be softer, more subtle, but the results are exactly the same. Now, today I want to provide a general overview of impediments to voting in Alabama, and then I want to focus on one such impediment, felon disenfranchisement. There are more we could certainly talk about. The history and complexity of current voting regulations is long, but my time to testify is short, so I will happily entertain any questions about any other area. From voter identification laws to curtailed polling places to limited polling hours to lack of early voting to no excuse absentee balloting, Alabama election laws disproportionately affect the voters in our state, even as they claim to improve election integrity. Such laws create barriers to voting in their reliance either on a one-size-fits-all notion of Alabama voters, in which every citizen interested in casting a ballot has access to the required identification and documentation, transportation, and the resources necessary to realize the right to vote. Or they rely on the notion that small impediments to voting are tolerable. Such perceptions and their harms are not justified by purported needs to ensure voter integrity. In fact, testimony received at the February 22nd hearing before the State Advisory Committee revealed that this was an illusory risk, that in fact, after the passage, or prior to the passage rather, of the voter ID law, there was no evidence of individual voter fraud in the state. Further, the state's position that until individual voters appear and complain that they cannot register, the government will maintain their position that all who want to register can. This not only mischaracterizes the true threat to Alabama's elections, but it adopts a position of willful blindness to the impact of such neutral laws on the very people these laws should work hardest to protect. Finally, widespread confusion over election law and voter requirements and inconsistent implementation of laws across and within counties exasperates this impact. Consider felon disenfranchisement in Alabama. The 1901 Alabama Constitution permits disenfranchisement of those convicted of felonies of moral turpitude. The definition of Moral Turpitude Act of 2017 served to decrease inconsistent application of the felony disenfranchisement rule by defining disqualifying crimes. Now, despite the standardization and limitation of such crimes, 7.62% of the state's voting age population remain disenfranchised, and the road to restoration is not smooth in Alabama. Confusion persists over whether or not those convicted of non-disqualifying crimes may vote while serving their sentences. The short answer is they can. They have never lost their right to vote under Alabama's law. And yet, their road to realizing that right to vote, even while incarcerated, remains complicated. Now, for those convicted of disqualifying crimes, they must apply to the Board of Pardons and Paroles for a certificate of restoration of eligibility to vote, or a CERV, to have their voting rights restored. CERV applications are neither routinely provided or available, and misinformation persists regarding the process for eligibility, in no small part because the Secretary of State's office that governs elections in our state has done little to disseminate information or to make such applications available. Finally, the requirement that CERV applicants have paid all fines, costs, and fees ordered at the time of sentencing on disqualifying cases in full creates a significant impediment to voting, particularly when coupled with the 30% collection fee tacked on to all such fines and fees, and it's imposed 90 days after the sentence has been imposed. Now, the Attorney General has issued an opinion that the collection of this fee must be paid in total before you can begin attacking the underlying debt. What this means is for those unable to make complete payment immediately, they will not be able to realize their right to vote. So once again, what's the result? The poor, who are already disproportionately impacted by the criminal justice system, face a barrier to realizing their right to vote. In conclusion, I cannot do justice to the myriad of barriers that the most vulnerable voters in Alabama face in 5 minutes. What I can tell you is that in my efforts to ascertain the lay of the land with regard to voting access in my state, I met with confusion, inconsistency, and frustration. I also met with the willingness of state officials and private actors to respond to inquiries and candor about the failures of the system and the law. Now, this gives me hope, but hope is not enough. Voting is a citizen's fundamental right. It's not earned, it's not given. It belongs to each of us. That some of us are able to realize this more completely than others should appall us all, and all of us should push to realize a system where the default is enfranchisement and not a series of hurdles that must be cleared to vote. I have one more paragraph, I promise. If ongoing debates in the current state General Assembly have taught me anything, it is that in a state like Alabama, controlled almost entirely by one party, there is little incentive to change at the state level. Until consistent and comprehensive federal policy is implemented, I fear that the inequity of the past will persist. Thank you.
Thank you all. We're going to start our questioning, and I would just say that on last week, the Secretary of State of Alabama came before our committee, and he said everything was wonderful here. I would now yield 5 minutes to Mr. Butterfield.
Thank you very much, Madam Chair. Let me just, since it's the most recent thing on my mind, Ms. Carroll, let me get back to you, if I can, very quickly. Are you saying that in order for a convicted felon to register to vote, they must completely satisfy their monetary obligation to the court? Is that right?
That is correct, and they not only have to satisfy their monetary obligations, and again, these are only for felonies that fall within the disqualified felony category.
Such as?
There is a long list. I'm happy to provide it in a supplement.
Property crime?
Distribution of drugs, some property crimes, not all, crimes of sexual assault, some additional crimes involving personal injury.
If you sell cocaine, you go to prison for 4 years, you get out of prison, you're a convicted felon, the court ordered you to pay restitution, cost, fines, and all of that. In order to register to vote, they serve the 4 years, plus they have to pay this money in order to register to vote.
Yes, and keep in mind, and I want to make this really clear, that not only do you have to pay those fines and fees, but during the time you are incarcerated, once that 90-day period elapsed, regardless of whether or not you're incarcerated, a 30% fee is tacked on to that. So you not only have to pay whatever those fines and fees are that have been ordered by the court, you also have to pay that 30% collection fee, and this is where it gets really challenging for poor people in our state.
Do you have any data that shows whether this disproportionately affects African Americans?
I can certainly look up data for that for you, sir, but I will tell you that...
If you could get that to this committee, it would be very helpful.
Well, and keep in mind the 30% fee has to be paid before you can attack any of the debt, too. So in terms of what can people expect their money to go towards, it goes to that collection fee first.
Talk to me about voter purging in Alabama, and then I'm going to get to you, Mr. Blackshear, and if I have time, I'll get over to Mr. Montgomery. Talk to me about voter purging. We have heard about this in other states. Is that an ongoing problem in Alabama?
It is. As I indicated in my written testimony, as well as we heard testimony at the February 22nd hearing, it is an ongoing problem. There's two aspects to it. There's purging from the rolls. There's also designation as an inactive voter. If you've been designated as an inactive voter, you aren't purged, but you have to complete additional paperwork before you can cast a ballot, even though you are entitled to vote at the precinct you arrive at.
I don't understand the public interest in purging an inactive voter. An inactive voter has the constitutional right not to vote, as well as she does to vote. I don't, if they are present in the community.
And I think that gets to the point that the default is not enfranchisement. The default is you have to prove that you are eligible and deserve to vote. And that's taking away a right that is fundamentally the right of the citizen.
Mr. Blackshear, let me get over to you if I can. Thank you for all the work that you've done in the voting rights space. As I said in my younger days, I also did the work that you're doing. In fact, Lonnie Guinier and I were co-counsel on many cases in North Carolina, and I have such fond memories of her. I'm sure you do as well. What is the average cost of Section 2 litigation? Let me build upon that just a little bit. Let me start with a small case. Let's say that the Board of Elections moves 3 polling place locations out of the African American community into another community that is not considered to be a voter-friendly community. Let's put it that way. And the African American community feels that this move is discriminatory. there is no Section 5 pre-clearance that would give DOJ an opportunity to take a look at it before it's done. So it seems to me that the only remedy is either to accept it or to litigate under Section 2. How much would litigation cost a private plaintiff? Let's say if 10 people in this audience lived in Precinct 23 and they wanted to challenge the moving of their polling location, how much would it cost them to litigate in federal court on average? Over $1 million?
Well, when it came to polling place changes, it would certainly cost at least hundreds of thousands of dollars if it was successful. And let me just say, Representative Butterfield, but back in 1982, I testified before a House committee regarding the Voting Rights Act and pointed out how expensive it was in the Mobile case to have to go back and prove intentional discrimination in order to get relief. That was one of the reasons Section 2 was amended to provide a result standard.
I was in the audience. Senator Hatch and Senator Kennedy were front and center that day.
That's correct.
Let me finally ask you this. Let's take a bigger case. Let's say you take a census here in 2020, right, and you're going to redraw the lines. Terry, in 2021, your district is going to be reconstructed. Let's say the African-American community is dissatisfied with the way that, what's your district number? 7. District 7 is reconfigured. And some private citizens want to litigate a redistricting case under Section 2. Wouldn't that cost millions of dollars?
Well, it certainly cost us millions of dollars in the last go-around of redistricting the House and Senate of Alabama.
But by contrast, if we had Section 5, wouldn't the burden just be on the state to present this map to the Department of Justice for pre-clearance?
Well, in fact, today, it is impossible for private counsel like me to bring one of these lawsuits without substantial assistance, financial and legal, from other from big law firms. Yeah. I mean, I've got 4 cases going on right now where I'm local counsel for the NAACP Legal Defense Fund, who's challenging photo ID, for the Campaign Legal Center, who's challenging the Felon Disfranchisement Center, for the Lawyers Committee of Civil Rights, who's challenging the at-large election of the Alabama Supreme Court, and the SEIU, Service Employees International Union, challenging them. And those organizations are needed to bring the resources just to get the case started.
I needed that in the record. Thank you very much. I yield back.
Thank you. Ms. Sewell, you're recognized for 5 minutes.
For the record, I just want to ask some questions just to make sure that the record accurately reflects what's going on in Alabama. And a lot has been said and not said, and you did provide a lot of materials written, but I think that it's important for us to state the current state of the status of voting rights in Alabama. Are there any African-American elected officials, statewide elected officials in the state of Alabama? Mr. Blackshear, yes or no?
There have only been 2 in the history of Alabama, Oscar Adams and Ralph Cook.
Secondly, Ms. Carroll, you said that Alabama's current state legislature, predominantly dominated by one party, the one-party system has not fared well for the poor and for vulnerable communities. That's what you testified to. Can you elaborate a little bit about that in the space, particularly about voter IDs? Can you talk a little bit about the most popular voter ID, which is the DMVs, and what happened in October of 2017?
Sure. In October of 2017, Governor Bentley made a decision, Republican Governor Bentley, and that is the one party that controls politics in the state of Alabama at the statewide level, made a decision to close a series of DMVs, 31 offices in predominantly black and poor counties throughout our state. As I indicated in the written testimony I provided, the ALEA, the Alabama Law Enforcement Association, and DOT, the Department of Transportation, conducted a study and concluded that that was going to disparately impact citizens who were predominantly poor, as you noted, and predominantly black.
And so what happened to that? Was full hours of operation reinstated, or what is the current state?
No. In fact, they were not. Not only were they not reinstated, but I myself found it very difficult to locate exactly what times offices were open in Wilcox County and in other counties that are predominantly African American. Now, you contrast that with predominantly white counties like Jefferson County or Shelby County. They have 3 DMV offices that are open 8 days a week. Or, I'm sorry, 8 hours a day, 5 days a week. Feels like 8 days a week sometimes. Bottom line is, you are much more likely to be able to go to a DMV office, the most common source of these IDs, according to Secretary of State Merrill, and get an ID if you live in one of these much more affluent, white-populated counties.
Okay, so more restrictive voter ID laws. Would you say yes or no in the state of Alabama?
Yes, we have among the most restrictive of any state.
Talk to me about transportation. Is it easy to get to polling locations, to get to these voter ID, the voter registrar offices where you can get your photo ID?
Not at all. Not only is it difficult to ascertain information about when they're open, what their locations are, but there's a lack of public transportation in Alabama, particularly in rural areas. And I say this as someone who grew up in rural South Texas, where y'all just visited down by Brownsville. It is hard to travel if you do not have access to transportation. And I've heard from voters who tell me that they waited, they were unable to get rides, or they were able to procure rides, and once they got there, the DMV office was either closed or the line was so long they could not get their identification.
Okay, can you also talk to me a little bit about what has been happening in the state of Alabama since Shelby versus Holder? One of the big things that was said in the dissent, it was, let's talk about the majority. The majority opinion by Roberts said that the states like Alabama were being penalized for what happened in the 1960s and 1970s. So we have to produce a modern day record of what's going on right now. Have there been any states or counties in Alabama that have been opted in to having to be pre-cleared, particularly Conecuh County? Can you talk a little bit about that? Yes.
Conecuh County.
Sorry.
Conecuh County, as far as I know, is the only it's not Conecuh County. It was the city of Evergreen in Conecuh County who, as part of a settlement disclosure, was bailed in for what we call pocket pre-clearance.
So they currently have to be pre-cleared. So even though we've gutted, Shelby versus Holder gutted, there's a city in Alabama, Evergreen, Alabama, that must have every voting law that happens pre-cleared.
Yeah, and we can thank Jerome Gray for that. Yes. That's his hometown, and but for Jerome Gray.
I have a few minutes. Yeah. Okay. I just want to say, in closing, can you give me one sentence that just sums up what the state of play is in the state of Alabama and what you, if you were sitting where we are, would do about it?
Well, it's going to have to be 2 sentences.
Okay, 2 sentences.
So, first of all, if you are poor, if you are a person of color in the state of Alabama, it is a longer, harder road to the ballot box.
Even today?
Even today. And I would say increasingly so. We've got an Attorney General's office that is consistently handing down opinions that makes it more difficult for people to exercise their right to vote. We are seeing budget cuts at the state level, which makes it not only difficult to travel in terms of transport, it makes it more costly to get the documentation necessary for ID, and it means that these DMV offices are going to continue to be closed during hours where working folks may be able to get it. What do we need to do? We need a comprehensive federal law that will deal with this.
Federal oversight?
Yes.
Thank you.
Thank you. I'm going to prepare to close this panel, but I just have one question, Mr. Montgomery. Do you think things are better or worse today than before Shelby?
I think they're probably worse since that time. I don't see much of that just say in DeCalera or in Shelby County area that I know of. Around the state, I have learned more. It's been a little bit more challenging in other places, maybe because the spotlight is still on Shelby County. Maybe everybody's watching Shelby County to see what happens. But again, the pre-clearance section is definitely the way to go.
Well, it's like my grandma used to say, the more things change, the more they stay the same. And what I'm hearing from you today, even Ms. Carroll, you were saying that the days of having a sheriff at the door are gone. No, they're not gone. When we were in Brownsville, Texas, they were telling us about having a polling place that was in a police station. Those days are not gone. we talk about felon disenfranchisement. When we were in Florida last week, the state of Florida last year voted by almost 65% to reinstate full voting rights to all felons who had served their time, self-executing. But the legislature on last week said they had to pay all their fees and fines or they could not vote. So they put a poll tax on these people that was not a part of the original amendment that passed by 65% of the voters. The more things change, the more they stay the same. I can only say to you that at some point, people of goodwill have to say something. People who are left out need to vote just out of spite so that these people will stop treating you the way that they do, because it is not going to stop until we do something about it. I'm going to close this panel and just say to you all, keep up what you are doing. The fight is worth fighting. And there's so many people who feel left out, who don't feel they have a voice, but your vote is your voice. That's the only time in this country that every single one of us is equal, is on Election Day. So I thank you all so very, very much for being here. I thank you for your testimony, and know that we are going to continue to try to pull together the data that the Supreme Court has said that we need to. Justice Roberts did not deny that there was still discrimination in this country. What he said was that I can't continue to punish states like Alabama because, you have old data and maybe they should not be under preclearance. Justice Roberts, if you're listening, they should always be under preclearance. I thank this panel. We will bring our new panel, our second panel up. Thank you all so very, very much. Nancy Abudu, Deputy Legal Director, Voting Rights Southern Poverty Law Center. Ms. Abudu leads a team of legal and technical experts dedicated to ensuring the voting rights of minority communities and other politically vulnerable populations, primarily in the Deep South. Isabel Rubio, Executive Director, Hispanic Interest Coalition of Alabama. HICA is a community development and advocacy organization that champions economic equality, civic engagement, and social justice for Latino families in Alabama. Mr. Similton, Sr., President, Alabama State Conference of the NAACP. Mr. Similton is a life member of the NAACP and has served as president of the Alabama State Conference of the NAACP since 2009. The Alabama NAACP is the oldest and one of the most significant civil rights organizations in Alabama. And last but not least, Mr. Douglas, Executive Director, Greater Birmingham Ministries. Greater Birmingham Ministries was founded in 1969 in response to urgent human rights and justice needs of residents of Greater Birmingham. The central goal of GBM is the pursuit of social justice in the governance of Alabama. Welcome to each of you. Ms. Abudo, you are recognized for 5 minutes.
Thank you. Thank you, and good afternoon, Congresswoman Fudge and this esteemed panel. I'm so honored by this invitation to share with you the travesties that the Southern Poverty Law Center and our partners have witnessed with respect to the dismantling of the franchise in Alabama and the disparate impact that Alabama's voting laws have on racial minorities, low-income people, and those living in more rural areas. SPLC did submit written testimony that provides more detail and citations to support the facts and figures we presented, but I remain more than happy to supplement that testimony based on the panel's inquiries today. So with my 5 minutes, however, I'll present a condensed version of a few of the major voting rights issues that the SPLC staff has witnessed and investigated across the state, and show how these problems are directly linked to the actions and inactions of state officials who see voting as a privilege to be earned rather than a fundamental right to safeguard. As we all know, Alabama has long been ground zero in the fight for voting rights, and it remains so today, unfortunately. The infamous Shelby County v. Holder case, which gutted the preclearance provisions of the Voting Rights Act, originated just down the road in Shelby County, Alabama. In the years since that devastating decision, Alabama lawmakers have enacted a bevy of laws that make it harder for citizens to access the ballot box while simultaneously declining to implement reforms like no excuse absentee or early voting that are now commonplace across the nation. I'm going to talk a little bit about voter turnout. Voter turnout in Alabama is regularly below the national average. In 2018, in the 2018 midterm election, only 47.5% of eligible voters cast a ballot in Alabama, despite historic turnout nationally. Alabama's top election officials have plainly expressed their view that casting a ballot should be a challenge. In 2016, Secretary of State John Merrill told a documentary film crew, and I quote, "If you're too sorry or lazy to get up off your rear and to go register to vote, then you don't deserve that privilege. As long as I'm Secretary of State of Alabama, you're going to have to show some initiative to become a registered voter in this state." He also expressed hostility to early voting on multiple occasions, saying, and again I quote, "There is no future for early voting as long as I'm Secretary of State." So this means that the man in charge of administering Alabama's elections freely admits that he does not see voting as a fundamental right that he is charged with safeguarding, but instead as a privilege reserved only for those with the time and resources to navigate the outdated and archaic system he continues to oversee. You talked a little bit about photo ID laws. You're going to have an opportunity, of course, to hear from Mr. Simelton and Mr. Douglas. I'm very honored that I had an opportunity to represent the NAACP years ago in the Shelby County case as interveners, and actually litigated or been investigating issues in Alabama for about 15 years in terms of, again, the needs that remain here. So we talked again about Alabama's photo ID. This was a law that was enacted initially in 2011, but not enforced until after the Shelby County decision, most likely because the state knew that if it had to go through Section 5 preclearance, it would be denied. So the NAACP and Greater Miami and the ministries that Mr. Douglas represents filed a lawsuit challenging the law as discriminatory based on their estimate that over 100,000 people, registered voters in Alabama, lack the necessary ID. So you're talking about almost 5% of the registered voters in the state who, simply because of this photo ID law, essentially are losing their right to vote. One of the main state senators who worked for over a decade, as far as we can tell, to pass this voter ID law was also quoted in media outlets as saying that his photo ID law would undermine Alabama's black power structure, that is a quote, and that the absence of a voter ID law, and again this is a quote, benefits black elected officials. And as many of these legislators who voted in favor of the photo ID law knew full well that everyone does not have the same opportunity to obtain one of these photo IDs. As you mentioned in the earlier panel, the closure of the DMVs quickly after the Shelby County decision and enactment of this law, and so we see that the real consequences that as a result of this voter ID law, people continue to be disparately impacted, and those individuals, by coincidence, happen to be voters of color and low-income individuals, which results in depressing voter participation in the state. Wow, my 5 minutes went by fast. So I just want to touch quickly also about voter registration. You all talked about voter registration and voter purges. Secretary Merrill is presenting confusing and misleading numbers when it comes to his voter registration rates. We have 3.6 million people who are a voting age population in Alabama according to the census form, but John Merrill presents that only 350,000 some odd people are not registered. He cannot present any evidence to support that low number. And if indeed that were the case, then Alabama would have one of the highest voter registration numbers in the country, not just in the South. And so our research is showing that he's playing around with the inactive voter list. What he's doing is, again, based on our research, is he's removing individuals from the voter rolls as inactive, and then if and when they actually reach out to the state to correct that information, he then adds them to the list as if they're new registrants, which in fact they should have never been removed in the first place, and then is claiming that his voter registration numbers are higher. We're showing that since 2015, he has removed over 780,000 voters from the voter rolls. We are asking Congress to investigate what is going on with those numbers. I'll also just quickly close in that out there, even though they're a minority right now, there are progressive-minded people in the state legislature. There have been a number of bills that have been presented to address some of the issues that you all are focused on today. House Bill 174 would allow, for example, those with disabilities to be permanent absentee voters. You've got two other bills that would streamline the rights restoration process. You've got two bills that would help to at least present some kind of modest early voting proposal in Alabama. So again, it is not that the state is lacking in ideas. We are lacking in political will to make these things a reality. Thank you so much.
Good afternoon. It's a real honor to be here with you. Thank you so much for your interest in Alabama and coming here to hear our stories. As you heard, I work with the immigrant Latino community here in Alabama. Have been doing that for the past 20 years. I can't really talk about voter suppression without talking about the relationship it has to immigration. And although immigration is a federal issue, you might know that Alabama in 2011 passed the harshest immigration bill in the country called HB 56, which was basically to make life for immigrants in Alabama so awful that they would self-deport. That was the explicit from the sponsor of the bill that said that. In that bill, you've heard today about the architecture of white supremacy in the state of Alabama. That bill, HB 56, was one more step in making sure that that architecture stayed in place. As part of HB 56, there was a provision that said that you must now require proof of citizenship in order to vote. It hasn't been enacted, but we know that placing that burden on families, on naturalized citizens, is just one more chilling effect that is taking place. We also know that the physical attributes, our last names, the way that we speak, make it difficult. Well, I'm from Mississippi, but at any rate, make it very uncomfortable for people in this state who might be naturalized citizens to take that step. Additionally, Alabama does have a fairly small immigrant or Hispanic population at this moment. We are hopeful with our 2020 census that we are doing a whole lot of work around to make sure that we count everybody, that we can show the country that we are really actually more than 4%, some of us being natural-born citizens of this U.S., but others of us eligible to naturalize. A big piece of the work that we do at the Hispanic Interest Coalition of Alabama is help teach people about their rights and responsibilities. One of their responsibilities being, if they are eligible to become a citizen, that is something that we need to help them along the pathway, and then clearly help them understand how important it is for them to register to vote and to get out there and actually do it. It is not lost on me, a woman born in Pike County, Mississippi in 1965, 3 weeks before Bloody Sunday, the importance of going out there and casting your vote, because you're right, we are all equal on that day. We do know, however, anecdotal stories that we have heard that people are jeered at, made fun of when they go to the polling place because they look Hispanic, they have an Hispanic last name. And so that real environment that we live in our state here and in our country, don't help the efforts that community-based organizations like ours do in order to help people make sure that they take seriously the responsibility they have to get out there and cast their vote. So at this point, I just again want to say thank you. This is a very serious issue in Alabama as it relates to immigrants, because the legislation that we have seen, the attitudes and the environment here is explicitly geared at continuing to oppress, marginalize, and further alienate people who want to be included in our community and to make really important contributions every day. Thank you.
Mr. Singleton, you are recognized for 5 minutes.
Test. Can you hear me? Okay. Good afternoon. My name is Bernard Simonson. I'm the president of the Alabama State Conference of the National Association for the Advancement of Colored People. To the Honorable Chairwoman Fudge, B.K. Butterfield, and our own Terry Sewell. It is an honor for me to be here today to share with you some of the experiences the NAACP has when it comes to registering people to vote and getting people out to the polls to vote. I was at the NAACP National Convention in 2006 when NAACPers from that convention marched to the Hill to convince our legislators that they need to extend a portion of the Voting Rights Act of 1965 for another 25 years. And I must say that we were successful in getting our legislators to vote in favor of that. President Obama, well, then he was Senator Obama, said, despite the progress these states have made in upholding the right to vote, it is clear the problem still exists, and I would carry that forward to today. And if we fast forward 13 years until 2019 and 54 years after the Voting Rights Act was signed, we see and ask ourselves, is voting rights equal for everyone? Is there equality in voting here in the United States and in the state of Alabama? And I think the answer is an absolute no, but we have made some progress, but the playing field is still not level. In 2013, I was at the Supreme Court of the United States and heard the argument for and against the constitutionality of the Voting Rights Act of 1965. And I heard then Justice Anthony Scalia say something to the effect that those arguing in favor of the Voting Rights Act must think that it is some kind of racial entitlement. And that was gut-wrenching. It disrespected the memories and pain of those who marched from Selma to Montgomery to demand the right to vote. We have experienced various forms of voter suppression here in the state of Alabama, especially since the Supreme Court's decision in 2013. And when the SCOTUS Supreme Court handed down the decision in the Shelby versus Holder case, Alabama legislators worked extremely hard to ensure that it is more difficult to vote and register to vote. First and foremost, Alabama implemented the photo ID law. When that ID law prohibited lots of individuals from being able to vote. It is estimated that at that particular time there was approximately 118,000 people who were immediately disenfranchised because they didn't have the photo ID required. In October 2015, Alabama closed numerous DMVs, mostly in the Black Belt area, and they closed this saying that there were a budget crisis and that they were going to save money by closing these DMV offices. However, if we look at the offices where they were located, most of those were in places that was donated to them, so there were no rent costs to them, and the officers who were managing these places, they were still on payroll, so there were no loss in income, no loss to the state budget because of them closing these DMVs, and I won't mean to say no loss, but there were no budget cuts. We also received a complaint from an individual who showed up for the polls to vote. When he presented his ID, they told him that he could not vote because he was on a felon. He said that I am not a felon. Lo and behold, he went to the office because he was not getting anywhere with the poll workers, and so he went to the to the registrar's office. And when he went there, after going around and around with the registrar, he eventually convinced them that they were looking for another person and not him that was not eligible to vote because of the felon, even though he presented his ID and the person that they had a different date of birth. And by the time he was able to get it all cleared up, the polls had closed and he was not able to vote during that time frame. We are currently engaged in a federal lawsuit under the Voting Rights Act against the Secretary of State in Alabama for implementing the photo ID law. And the lawsuit is currently pending before the Federal Court of Appeals. In addition, the NAACP became aware in 2012 that Alabama was not in compliance with the National Voter Registration Act of 1993. It's also known as the Motor Voter Law, that requires agencies such as the Department of Human Resources, Medicaid, Department of Motor Vehicles to offer individuals the opportunity to register to vote when you come before them. And our own Secretary of State has said that he knew that Alabama was not in compliance with this law, but had taken no action to put us into compliance until we brought this to their attention, and they offered to offer registration to people who visit their office. And they presented the data on a quarterly basis of how many people they registered and how many people visit their office, so we could see how many people they were actually registering. The NAACP and others entered into agreement with various Alabama state agencies for them to take active measures to offer their customers the opportunity to vote, by putting up signs and things like that, making sure that people knew that they could vote, they're registered to vote at these places. Just a couple more, and I want to share with you. Escambia County voters experienced a significant number of voters whose names were mysteriously discovered absent from the roster during the midterm election in 2018, as well as the presidential election in 2016. And during the midterm election in 2018, at least 4 students from Alabama A&M University were not registered to vote after their turning in their registration forms. And one of these students had registered online, and the others had registered through a on-campus voter registration effort. Finally, I'd like to say on behalf of the Alabama State Conference of the NAACP, I appreciate you all listening to us and other participants this afternoon, and I hope our testimonies will provide you with the ammunition you need to convince Congress to act to put voting at the top of the agenda. We are ready here in the state of Alabama to take our turn this around, but we look to our esteemed legislators in leading us through this effort. Thank you very much.
Well, thank you and welcome, and thank you for holding hearings in the state whose struggles and sacrifices gave the nation the Voting Rights Act of 1965. Great Birmingham Ministries is 50-year-olds interfaith organization where Jews, Christians, Muslims, black, white, and brown united in providing emergency assistance to low-income families and working together to improve those systems of private and corporate practices and public policies that affect the poor unjustly. Our work addresses housing systems, healthcare systems, transportation systems, the criminal justice system, and most importantly, the voting system that impacts them all. For decades, we have conducted voter registration among the families we serve each year in terms of needs of coming for assistance for utilities, food, clothing, housing, disaster assistance, and other emergency assistance. And since 2007, we've expanded our voter registration drives by going into low-income neighborhoods, hospital waiting rooms, the Central Bus Station, Jefferson County Jail, and even the Mag City Classic. For GBM, our fundamental principle is that no one should be denied access to housing, education, health care, transportation, or justice. This principle is embedded in holy text, not the least poignant verse of which is Proverbs 31, verse 9, which proclaims, yes, speak up for the poor and helpless and see that they get justice. Because access to decent and affordable housing, quality health care, reliable transportation, and increases in the minimum wage are determined by public policies made by elected officials, GBM believes that access to the vote for poor people is fundamental inside who gets to make public policies and how those public policies take shape. When the voices of the poor are diminished, public policies reflect the absence of those voices. The voices of the poor with often dire consequences for their quality of life and the quality of life of us all. Without the protection of the guts of the Voting Rights Act, the pre-clearance provision, the changes in Alabama's voter ID laws placed a tremendous burden on already economically and socially burdened black and Latino and other poor families. The poll tax was established to suppress voting, so money is a burden. In Alabama, even obtaining the so-called free state-issued photo ID requires people to draw on scarce funds to compile the underlying documents. The list of accepted documents required to obtain a voter ID card is limited and includes, for example, a birth certificate, hospital record, census record, military record, Medicare and Medicaid document, Social Security document, certificate of citizenship, or official school record or transcript. Many of these must be requested from a government agency and may include a fee. Transportation is a burden for low-income people that is not so obvious to any of us who have reliable transportation. If you are poor and live in urban areas, you can't rely upon public transportation to get you to the polling place before work or home after work. But the added burden of first having to get to the nearest driver's license office in urban areas to procure the proper ID to vote. And in many black belt counties, if there's a car in the family, it's being used by the breadwinner who has to use the car to get back and forth to work, often in a neighboring county. GBM has direct experience with low-income people burdened by Alabama's photo ID law. Through litigation, we became aware of Elizabeth Ware. She is an African-American woman who regularly voted before the photo ID law was passed. However, her non-driver photo ID was lost, and she did not have any of the other forms required to vote. And due to her fixed income, lack of reliable transportation, and limited mobility, the law prevented her from voting. Ms. Ware's income was solely Social Security disability as a result of serious maladies. She does not drive and has limited transportation options. The bus stop is 5 blocks away from her house, and walking that distance takes over an hour and causes pain. And rides by car are unreliable. The nearest license commission where she could have gone to get an ID was not in walking distance, and a ride cost $20. A significant amount for somebody on her income. She was finally able to get a ride to the board of registrars where she attempted to get a free voter ID card. However, she was wrongly denied the ID by a staff member who had been improperly trained and told her that she had an ID in the past. That because she had an ID in the past, she was ineligible for the voter ID card, despite her current circumstances. Finally, after becoming a plaintiff in the case challenging the photo ID law, Ms. Ware's attorneys arranged for the Secretary of State's office mobile unit to visit her home during her deposition. She had never heard of the existence of a mobile unit prior to litigation. And about those mobile units, they would take them sometimes to rural areas and park them in front of a library or the county courthouse where you could also get your voter ID. We thought it would be like a bookmobile circulating. No, they parked it when you went out already. Anyway, finally, the mobile units process was deeply flawed and faced many technical issues. Ultimately, it took over an hour to issue Ms. Ware a temporary ID, and she had to wait for a permanent ID to be mailed to her. This process clearly cannot be replicated for the thousands of people in Alabama who do not have ID or reliable transportation to get to a board of registrars. Had Mrs. Ware not been a plaintiff in a lawsuit, it's unlikely that she would ever have been able to obtain the required ID. Alabama's photo ID law is the new poll tax, but the reason for its existence is the same as the original one. Thank you.
Mr. Butterfield, you're recognized for 5 minutes.
Thank you very much again, Madam Chair. Again, thank the four of you for your testimonies today. They will be very helpful in our work. Let's talk about 2021. And I guess I'll go to the Deputy Legal Director. Since I can't pronounce your last name, I'll do it that way. You're going to have a census in 2020. And the legislature is going to take that data, and in 2021, they're going to draw a congressional map. They're going to draw some legislative maps in the state of Alabama. Am I correct?
That is correct.
When they did that 10 years ago, after the map was prepared, wasn't the map submitted to the Justice Department for pre-clearance?
That's correct.
Now, in 2021, they will not be required to submit the map for pre-clearance.
That is correct.
Which suggests to me, and you correct me if I'm wrong, it suggests to me that the legislature kind of has unfettered ability now to manipulate the maps, unlike they have been able to do in the past.
Absolutely, you are correct.
Now, with 7 congressional districts, it appears to me that perhaps Alabama may be entitled to pick up an extra majority-minority district if the lines are drawn appropriately and fairly.
That is very possible. Because
Ms. Sewell, I believe, has about 65% African-American percentage in her district. And I believe that if, I remember when Mr. Hilliard was first elected some years ago, just like my state of North Carolina, the way we got these majority-minority districts was through Section 5. Once the state prepared the map, they sent it to DOJ. DOJ said, we don't like the maps, do it again. And the states had to redo the maps, and that's how Mr. Hilliard was elected. That's how Eva Clayton in North Carolina was elected. But now the state of Alabama won't have to do that. And so Alabama can just implement some maps. They can pack black voters into the 7th district, or they can crack the black communities. We call it cracking. That's not an obscene word. That's a legal word. They can crack African American communities and spread them in different directions so that minority communities won't have any influence anywhere. And if you don't like that, you cannot resort to Section 5. You have to resort to Section 2, which is a multi-million-dollar exercise. And in terms of redistricting, you can believe it will be many millions of dollars to litigate such a claim. And so have I said anything that's incorrect thus far?
No, everything you said is unfortunate, very sad, but absolutely correct.
And if private citizens, these good people in the audience today, wanted to bring a Section 2 lawsuit challenging 2021 redistricting, wouldn't it cost millions of dollars to do that?
It would cost absolutely millions of dollars to bring today. It forces us into not only spending that much money, but also into a venue through the federal courts, unfortunately, that are becoming more and more hostile. As this panel knows, the U.S. Supreme Court recently heard 2 redistricting-related cases, one involving partisan gerrymandering and one dealing directly with the census and the counting or the requirement that people state their citizenship. And this falls right in line with what Ms. Rubio does.
Yes. Let me go to Mr. Similton. Thank you very much for all the work that you do. Similton here in Alabama. Reverend Barber is my son, not really my son, but he is my son. He's my constituent and friend, and I've mentored him since he was a very young man, and I'm sure you know him very well. In Alabama,
yes, sir,
across the state, are there municipalities and counties that still have at-large election systems?
Yes, and I'm glad you brought that up because we're currently involved in a situation over in Pleasant Grove where they have, it's probably about 45+% African American, and they have no black on the city council And so we are involved in a situation there to try to get them to go to
Well, you
district.
just opened the door to my question, okay? You've got a 45% African-American city, no African-Americans on the council, okay?
Right.
That tells me that there's racially polarized voting in that municipality,
Right.
which means whites don't vote for African-Americans, at election time.
Right.
Now, anytime there are annexations, you still have annexations in Alabama, I suppose. Anytime you annex areas that are high rent, high cost into a municipality, that suggests that more white families will be moving into the city, which dilutes further the African-American, the effect of the African-American vote. That's how we used to use Section 5. If a city wanted to annex areas into a city, they would simply send the annexation up and get it approved or disapproved. And once in a while, DOJ would say, well, no, we're not going to approve it unless you go from at-large elections to district elections, and then you can have your annexations approved. In the city of Rocky Mount, North Carolina, which is in my district years ago, same thing. We had a 45% African-American city, no African-Americans on the city council. The city wanted to annex 19 areas in the city that were going to be white. Section 5 came in and said you can't do it. If you go to districts, you can do it. City went to districts, and now we have 4 African-Americans on the city council and 3 whites on the city council. That was the power of Section 5 then,
Right.
and it can be the power of Section 5 now. Thank you, Madam Chair. You're back.
Thank you. Ms. Sewell.
Madam Chair, in my 5 minutes, I want to make 3 appeals. First, I want to appeal to my colleagues. I want to thank you for coming to the state of Alabama, and I want to remind you of our job. Our job was stated very clearly by Roberts in the Shelby versus Holder court. He said, a statute for Congress to establish a new coverage test, a statute's current burden must be justified by current need, and any desperate geographical coverage must be sufficiently tailored to meet the problem at hand. To my colleagues, we need federal oversight here in the state of Alabama. I understand that we have states' rights, and I fight vehemently for our states' rights. But when our state is not exercising that right on behalf of all of its citizens, we need federal oversight. So my appeal to you is to remember the 5 things that you've learned today. You've learned today that the state of Alabama has more restrictive voter ID law now than it did before the Shelby versus Holder case. You learned today that the problem disproportionately affects minorities, rural communities, the elderly, and the disabled. That there is a cost associated with these photo IDs. The price of freedom, we know, is never free. It is paid by those who have fought for this right that we have and fought for us to sit where we sit in Congress to do the right thing. The third thing we learned is that we have limited access in Alabama. Closing DMVs in majority black counties limit the ability of black voters to get the most common use of an ID, which is the driver's license. Thirdly, you've heard from our Hispanic population, our Latinos, that the attempts to require proof of citizenship for voter registration is just a modern-day form of intimidation. It's not right. It's not fair. The fourth thing you learn is that we have in Alabama aggressive voter purging laws. A nationwide study by the Brennan Center found that between 2014 and 2016, states removed almost 16 million voters. And they found out that in the state of Alabama, our Secretary of State says 658,000 voters have been purged from the rolls since 2015 in a state that only has 3.3 million registered voters. That's 658,000, he personally said, in a state that has 3.3 million voters. And lastly, you've heard about closing polling locations and moving polling locations without notice. All of those are modern-day facts of things that are going on in the state of Alabama that show a burden. And I'm here to tell you that there is a need for federal oversight, and we must do our job. I believe our job is to pass a new law that will require and put the guts back into the Voting Rights Act of 1965 by giving these modern-day formulas. Okay, my second plea is to our witnesses. To our witnesses, continue to do the good fight in your organizations, but we must document. We must make sure that we have evidence, factual evidence of voter suppression. We know it happens. We hear about the anecdotal evidence, but we must have factual evidence, and we must submit that to Congress. Please do that. And lastly, my plea is to the audience. We are the people. If you see something, say something. And most importantly, do something. Everyone should go to the poll with another person. No one exercises our rights but us. We have got to do our part and go to the polls and vote. Because what Republicans will continue to say is that as long as we have voter registration drives, as long as we have voter turnout, that there's no need for the Voting Rights Act of 1965. What they fail to realize, and it's disingenuous on their part, is that just because you can go and register to vote, just because you can turn out to vote, doesn't mean that their laws don't cause voter suppression. They're not mutually exclusive. And so what we have to do in this audience, my plea is to the people. We need to go out and vote in numbers that we've never seen before. In every election, federal, state, and local elections, because that's the only way that we're going to turn it around. And I would be remiss if I didn't acknowledge the foot soldiers that are in the audience. I saw some foot soldiers in the audience. Stand up. We stand on their shoulders, but it's time to get off their shoulders and do our own work. We have to do our own work. I invite all of you to come to a reception to meet my colleagues after this hearing. But I want to say to my colleagues, thank you for coming to Alabama. We need help. We need federal oversight in the state of Alabama.
All right, we hear you. We hear. Now, I'm only going to disagree with one thing you said. I don't fight for states' rights. Because whenever I hear states' rights, I think slavery. That is what kept us in slavery. That is what is trying to enslave us again today, is states' rights. That's the only thing that you said I disagree with. Now, I think it was Langston Hughes who penned the words, "I too sing America." This is my country, and I am a patriot. I have been sworn to uphold the Constitution of the United States. And I do that every day. But I need everybody else to uphold the Constitution of the United States as well. The Constitution says that every single citizen has the right to vote, an unfettered, unabridged right to vote, which means that I believe it's unconstitutional to take away rights for those who have been incarcerated. We don't take their citizenship. They are still citizens of this country. People who are naturalized citizens are still citizens of this country. The Constitution says to us that you have a right to vote. It doesn't say if you don't vote in one election or two that you are purged from the rolls. It is unconstitutional. It doesn't say that because it's not a use it or lose it. It says you have the right to vote, the unfettered, unabridged right to vote. And we have to start to talk in those kinds of terms because they would make us think that we don't know the law, that we don't know what the Constitution says. I know my rights, and we have to start to exercise our rights. You know, people think that as we listen to rhetoric today about making America great, let me say a couple of things about greatness. One is that America is great because Americans are good.
That's right.
That is what makes this nation great. And what makes this nation great, in the words of Alexis de Tocqueville, is that we have the ability as a country to repair our faults. What has happened to us over the last 13 years is a huge stain on this nation. And so what we are doing here as a body is trying to repair our faults. We are going to fix this. We are going to give them the data, whether they choose to accept it or not. We are going to say to them, be careful what you ask for. There is as much voter discrimination and suppression today as there was in 1965. Schools are more segregated today than they were in 1968. Neighborhoods are more segregated today than they were in 68. The more things change, the more they do stay the same. And so we're going to tell the truth. We're going to give Terry the formula to put into her bill so that we can create a new formula so that we can fully reinstate the Voting Rights Act, Section 4, as well as some changes that probably need to be made to Section 5. So I want to thank you for being here to give us the ammunition that we need to go back to Washington and to continue to do our jobs. I thank you all so very much. I want to thank the witnesses for their testimony, the members for their questions. I want to thank the staff and all of those who made this happen, the people here at City Hall. Again, the witnesses, we may have some other questions. We'd ask that you respond in writing. All of my colleagues, all of the people of Alabama, thank you so very, very much, and this subcommittee stands adjourned.
Thank you. All right, Governor